Looks like it is 9 o'clock. So on Tuesday, August 12th, 2025, welcome to oral argument Zoom session with the Fifth District Court of Appeal. I am Judge Brian Lambert. I will be presiding today in oral arguments. With me on the panel, you can see on our screen, are Judges Edwards and Soud. We have one case this morning by Zoom. It's case 24-0210, Peninsula Insurance Company versus Justice. Each side will have 20 minutes. You'll see the clock. It's up in my upper left corner here. I'm assuming it's somewhere on your screens. Appellant, it will default to 5 minutes for rebuttal. If you want additional or less time, please let the marshal know now, and he will set the clock accordingly. When the yellow light starts beeping or flashing, I guess it won't be beeping, flashing, that'll tell you you're into your rebuttal time. You can use as much or as little of that as you want, but total 20 minutes for the appellant. We are being live streamed, so please, if you have any type of devices on, please either turn them off or in the mute so you do not disturb either your opponent, opposing counsel, or the court. That said, counsel, if you are ready to proceed, you may.
Thank you, Your Honor. May it please the court, and for Mr. Marshall, I would like to reserve 8 minutes rebuttal.
All right, very well.
This case involves a cast iron pipe plumbing system. The loss, according to the record, began to occur in November of 2018, and there were repeated instances of water backups and water leaking through the drain lines for the next 6 months. The loss was finally reported in June of 2019. Florida Peninsula paid at actual cash value in July of 2019. Based upon the only actual cash value estimate that it had. Up until the time of trial, Florida Peninsula never received a competing actual cash value estimate for the loss. Suit was filed, and although the plaintiff in that case at trial claimed to be only claiming actual cash value, they also defined actual cash value as replacement cost value without matching. So, in fact, they were seeking actual cash value at the trial level. There were several issues at trial, the first one being the correct measure of damages. And because the record is replete with testimony about the fact that the plaintiff in the underlying case never performed any repairs to the property, under Florida Statute 6277011(3)A, as well as the policy of insurance, the proper measure of damages for a paid claim or a covered claim is at least actual cash value unless and until the repairs are performed. And then the cost to actually perform the repairs can be paid as those costs are incurred and as the repairs are made. That never happened in this case.
Counsel, let me ask you a question.
Certainly.
Let me jump ahead on a different one. On the constant or repeated exclusion that you raised, hypothetically, if we agree with your position, would it be a reversal of the final judgment in its entirety, or just a reversal as to the tear-out costs that were assessed by the jury and awarded in the final judgment?
It would be a reversal in its entirety because this is an exclusion that is actually listed under the exclusion section, which carries the anti-concurrent causation language as the lead-in. So if this constant or repeated, and or is the operative term here, constant or repeated seepage and leakage of the water and exposure to moisture for 14 days or more, if that is a contributing cause, the entire loss is excluded. And that would be under the doctrine under SIBO and the exception to it under Seluzniak.
In order for the exclusion to apply, would it be required that the constant leakage cause the pipe failure?
No, what this lead-in language says is, um, excuse me, we do not insure for loss caused directly or indirectly by any of the following. Such loss is excluded regardless of any other cause or event contributing concurrently or in any sequence to the loss. So in other words, if a covered loss occurred and the insured let it continue without any intervention, and there was testimony by the insured as well as their expert, Dennis James, and their plumbing expert, that every time a toilet flushed, anytime anything happened, it would reoccur. It doesn't have to be constant. It can be constant or repeated seepage and leakage or exposure to moisture. And so she testified that beginning in November of 2018, it began to occur. She goes through several instances where there were more occurrences. She reports 6 months later, and even at the time of trial, had not done any repair. So it was really years of exposure to moisture, but at least 6 months before it was even reported. And so no, in answer to your question, Your Honor, it just has to be a contributing cause, and it doesn't matter how much it contributes. Just, I think the tenet here is that even when you have a covered loss, you can't just let it continue and get worse for weeks and weeks. And in this instance, it was months.
What did the plaintiff's expert say regarding the constant or repeated exclusion? I mean, he didn't say it exactly that way, but
No, Mr. James actually said that, let me see if I can find it here.
I thought it was Mr. Jaremko.
Jaremka, I'm sorry, it could be Mr. Jaremka. He actually made a conclusionary statement that it's not repeated, constant and repeated seepage and leakage, but he used the word and he said, he interpreted the policy himself on the stand and said, for it to fall under that category of constant and repeated seepage and leakage, it would have to continue constantly. And we can see that that's not what this policy says. It says constant or repeated. And he testified and the insured testified that there were instances, and I believe he said something like there were several instances, but they were only 10 seconds or 30 seconds, and then it would stop. Well, that fits the definition of repeated seepage and leakage. And we know just from our timeline that it was over 6 months.
So you think the 6th DCA kind of addressed this fairly helpfully in your case here during the course of briefing? In the Feltis case?
Yes, Your Honor.
In fact, that's ironic. It's exactly Mr. Nation and the expert in that case, wasn't it?
Exactly.
And actually, the Feltis case was issued on the same day he wrote his brief. He filed his brief here today in this case.
It's we see the same players in every case.
Oh, okay. Well, at least that one and this one we do.
That's
We
right.
do. I guess you guys may see more. I don't know. So you think that Judge Nardella got it right in Feltis and that it's eerily similar testimony in that case, in this case, same issue, very almost identical provisions in the policies. And so
Absolutely.
I know you've raised 143 different issues here, but that one is, I'm just kidding. I mean, 6 or 7. That one you is dispositive in and of itself, is I guess, if I understand your position in your brief.
Yes, Your Honor, we believe it is dispositive, and we believe there was very clear, uncontroverted testimony. And just because Mr. Jaremko comes to a conclusion that it doesn't fit the definition of it under the policy, doesn't make it so, because this policy says constant or repeated. He testified clearly about repeated seepage and leakage, as did the insured. And we know from the lead-in language that it doesn't matter if it's before 14 days or after 14 days, if it contributes in either at the same time or any sequence to the loss, if it is part of the damage, then the entire thing's excluded. And we know that the inspections and the estimates of plaintiff's experts were in 2023. So they're not going to have an estimate of the first 14 days.
How do you think our court's decision in Hicks applies to the analysis of this exclusion and this argument we're having today, or for you guys?
I think this hinges on the lead-in language, this anti-concurrent causation language, because the argument in Hicks did not include the anti-concurrent causation language. And this clearly says cause directly or indirectly in any sequence. So even if there's a covered loss, if this situation, this condition of repeated seepage and leakage contributes to the damage, then the entire thing's excluded. And it specifically addresses a covered loss and a non-covered loss. So let's just, assuming arguendo that there was a covered loss, this exclusion for repeated seepage and leakage only has to contribute to the damage. And it actually says, which occurs over a period of 14 days or more. And
Well,
I
what
believe
about during the first 13 days, when that be a covered event regardless of?
No,
what
because
happens
this says which occurs over a period of 14 days. I believe in Hicks it was more than 14 days. Here it is over a period of 14 days or more. So it's 2 weeks or more, and she didn't even report it for 6 months, and no one had been out there to estimate. For instance, APT came out to estimate damage, and their report is dated July of 2019. So no one estimated the damage during the first 14 days. And normally at trial, Mr. Nation will argue, well, we're not seeking anything more than the 14 days. We just want that 14 days. That's a very convenient argument, but where's the estimate for the first 14 days? And where's the opinion that it never got worse on day 15? No one knows, because we didn't get to see it for 6 months. And they don't have an estimate. One of them is for 6 months later, and the other two are from 2023.
Well, I guess we can ask Mr. Nation, because apparently he was on the Hicks case too.
That's correct.
Maybe you're right. Maybe he is on all these cases. See, I was on that case too. All right, you should ask me. All right, go ahead.
So there were several issues here. We talked about the ACV issue, but most importantly, under Goldberg, which, you know, as I look at it this morning, I'm not sure Goldberg is cited in our briefing, but under the Goldberg case, a company can't be found to have breached when they paid on the only ACV estimate they had. And that's exactly what happened here. We never had a competing ACV estimate for water damage prior to this lawsuit being filed. And even though plaintiff claims they had an ACV estimate, Vasquez, after 6277011 was revised, that statute, which used to be known as the replacement cost value statute, became an ACV statute where a company only has to pay ACV. And after that came out, Vasquez defined what ACV is, and it is the value of the covered property that suffered direct physical damage. And what Mr. Nation does is he includes tear out in his ACV estimates. And of course, tear out is the tear out of undamaged property to access a plumbing system. It's not damaged. It doesn't fit the definition of ACV. And his experts get on the stand and talk about how it's all the costs needed to repair, less depreciation. And since Vasquez came out, they won't include matching because Vasquez happened to be about matching. But the important point to drive home here is that the rule of law that came out in Vasquez is the definition of ACV.
Counsel, you're into your rebuttal, but you can continue on as long as you want. So.
Oh, okay. I'll actually stop here and
you don't have to. You understand? You just asked me. Yeah.
I didn't notice, and I appreciate the heads up there. I'll save the rest for rebuttal. Thank you.
All right, counsel.
Good morning. I'll start addressing your questions. I can see what you're obviously zeroing in on, and I'll talk about Feltus and Hicks and the interplay and the facts of this case. I want to point out, though, in this case, we have damage caused by a drain line. And so the water that escapes will only escape when the drain line is in use. Flush a toilet, so to speak, or wash a machine. We have damage to the interior of the home, separate and apart from fill. We have damage to the kitchen and other areas. They agreed with that and paid something for the interior damage. As to Feltus, Feltus has two parts. The first part talked about the interior damage under the State Farm policy. State Farm's policy says that they will only pay for tear out for the specific point from which the water escaped. And so they deal with the interior damage, and they said under those specific terms of that policy, we don't have that language in this policy. In that policy, there's no coverage for the interior damage because the water came out of the lip of the toilet, and so we're not going to have that. And to the extent counsel in a rebuttal argues that it's the same language, I just refer you to the policy. It tells us what tear out is available, and it doesn't have that specific point from which the water escaped. And so the interior damage in Feltus, not covered. And that left only the damage to the fill. And they said, in that case, the damage to the fill was excluded under their constant repeated seepage or leakage language, which is different than ours. Theirs is over a period of time. I'll get the exact language. I think it says a period of time or over, let me see, I've got it right here. Over a period of time. Ours is Hicks language. And so that's a distinction between these two policies. And so the interior damage in Feltus, we can't get tear out because of that specific language. Here we have interior damage. Now, at DV, what they're saying here on appeal is that the trial court made a mistake in not granting DV. But if you look at their DV argument, starting on page 864 of the transcript, they did not argue damage to the fill was excluded under constant and repeated leakage or seepage. They did not cite any case or any testimony in their initial brief concerning that. Feltus came out, and then in their reply brief, they dealt with it. What they argued at DV was that the losses to the interior were constant and repeated leakage or seepage. It wasn't. And I could go through the testimony that shows she did have some problems. She fixed them. She replaced her washing machine. Then she replaced her dishwasher. Then she replaced her garbage disposal. Then replaced the washing machine. It caused a leak. And on 3-1, our backup and overflow, in a single event, and she stopped using it on March 1st, 2019, and didn't use it anymore. The language in their policy is exactly the same as Hicks. And Hicks tells us the first 13 days is covered, and anything that they claim is excluded after the 13th day, the burden of proof is on them. And that issue went to the jury on constant and repeated. And they were free to argue the facts in that case. There was no error in granting or denying their motion for directed verdict, as they didn't argue fill. To the extent that the court were to find that fill is excluded even under the 14-day issue, if it was excluded, the only thing in our estimate for fill is $293 for hand pulling the fill out and $1,383, and that's in the tear out estimate, $1,383.94 for recompacting that fill. Those two line items were necessary regardless of any damage to the fill. The testimony is clear. You tear it out, you remove the fill, whether it's damaged or not, you put in new pipes, and then you have to compact it. And those are the only two line items for fill in there. So to the extent that the fill would be excluded, although I don't believe they can carry their burden of proof under the terms of this policy, to the extent it was excluded, it would be harmless error because it's necessary for the tear out as a result of the interior damage. Let me see if there's anything else on that. As to the 14 days, if you have a dishwasher, I'll just say, that has a backup on Monday and it causes damage, that is damage. That is a event that occurred. Tuesday, you don't run the dishwasher. Wednesday, you don't want to run the dishwasher. What they're saying is Monday, Tuesday, and Wednesday are 3 days into your 14 days. It's not. This is, unlike Hicks, Hicks was a supply line, which was constantly shooting out of the refrigerator for more than 14 days. In that case, court was clear. The first 13 days is covered. To the extent the insurance company wants to exclude anything after that 14th day, the burden of proof is on them. And there is no evidence. And in fact, I think there's no evidence whatsoever what damage in this house, interior, was exposed to 14 days of loss. What they're saying is there was a loss, say a dishwasher backed up, and it wasn't reported until much later. But the clause is clear. They don't cover loss caused by constant repeated leakage or seepage. They're leaving out the cause, and that's why, Judge Lambert, in Hicks, y'all underlined the word cause twice, because they're doing the same thing here that they did there. They're ignoring the cause. What they're really saying is it was late reporting, and that issue went to the jury. Late reporting's on the verdict form, and they lost late reporting on the verdict form. And so, let me see if I have it. And it has to prove for their constant repeated leakage or seepage to apply to a total bar to recovery, they got to prove that all of the damage was excluded under that. They can't say, well, the fill's excluded, and so the whole claim is excluded, because the exclusion for constant repeated leakage or seepage didn't apply to the interior damage. We could leave the fill completely out of this. They still get the exact same recovery that we got. And we got every penny of our tear out estimate. And to the extent they're arguing, let me complete that thought. We got every penny. You add up the water damage plus what was given for tear out, that is to the penny what our tear out estimate was. Now, they were told, the jury wasn't told, you can't give the water damage to us twice, because that's going to be, the water damage is really inside the trench that's going to be done, and that would be double dipping. But we got every penny. And so Hicks seals the deal. We don't have to produce an estimate of what, quote, damage we're seeking for the first 14 days. They have the burden of proving what damage is excluded. And they didn't do it. I think in the DV argument, counsel said, nobody knows how long those pipes had been leaking. And that can be found in the DV argument that they made. I'll find it. I don't have it here. But they said nobody knows. Well, the burden was on them to prove what loss occurred after the 14th day. If we're talking about the fill. Interior, that's just a fact question. The timeline's clear. She had some problems, dealt with them. Then she had a backup to overflow, stopped using the washing machine. Again, what they're saying is, well, she didn't report it timely and didn't fix it. But she stopped using it on March 1st, 2019, and that's clear in the evidence. But that issue went to the jury. And if the fill's excluded, that doesn't mean the interior is excluded. They don't get to exclude the entire claim. And again, that's harmless. Let me make sure I'm done with constant repeated leakage or seepage.
Wasn't Hicks a little bit different because there was a continuous flow in that case, unlike what we have here? And
100%.
Didn't you raise the issue of, oh, by the way, we should, I mean, it was framed on a summary judgment, wasn't it, as to the 13 days or not? And
Yes, sir.
they
Their
didn't,
summary judgment.
right, and they couldn't show conclusively that you weren't making that claim for the first 13 days?
That is that, and it wasn't, that's why I made that point earlier, and I'm glad you brought it up. Hicks was a supply line, pressurized line, constant, literally constant. And so it went for, I think it was like 31 days or something.
And
Now,
it kept getting worse.
correct. And we said, we're not, I think the end of the opinion says anything damages are up to the jury, and anything after the 13th day, they have the burden of proving that, and the amount of the damages we're seeking is excluded. And they haven't done that in this case. This, though, and that Hicks is a easier case for the defense. Here, we've got, let's say, a dishwasher overflows on Monday, isn't used again for a week. They're saying that's 7 days of constant and repeated leakage. That's 1 day, maybe 2. It's not a pressurized line. But that would only apply to the fill, because the jury clearly determined that as they had the history of the interior, the kitchen, the plumbing inside the house, and they decided that inside there was no constant and repeated leakage or seepage. And so,
So let me ask you this: what does repeated mean? Constant, I get that from Hicks, but
there's
here
a
you've got
couple.
your dishwasher, the toilet, the tub. You've got several different things overflowing, which your expert says is because the cast iron pipe underground is compromised, and so over a period of time, every time they actually use it, it does have a problem.
So, and I don't think it was a tub. I think it was it was a dishwasher.
Well, she used a hose to route the tub outside, I thought. Maybe
I think it was
a
the
laundry
washing
tub, I don't
machine.
know.
It was a washing machine, and she did that on March 1st, 2019, when she got a brand new washing machine, and then she routed it out there. And so if that is an event, but if you go through the timeline, and I have the chronology here from the testimony, in November or December of 2018, she had a leak under the sink. And she replaced the PVC pipes in the brackets under the sink. At that time, the leak under there had stopped, but it kept backing up. A backup in the sink is not a leak. So she fixed that. Then after that, there was some water coming out from under the dishwasher. She didn't keep using it. She removed the dishwasher and installed a new one. The new one, then in December, had water coming out of it. At that point, they took out the garbage disposal and ran a straight pipe out. And so we have these discrete events. And then the plumbing, the laundry room backed up. She got a new laundry washing machine. It backed up. She disconnected it. Discrete events. The jury was faced with that and concluded that isn't constant or repeated leakage or seepage, because that didn't cause the damage. Those are events that occurred. The event we're here about is March 1st, 2019. There was a flood in the kitchen. The insurance company opened coverage for that, and that is what they paid on. The jury heard all of that and determined that that wasn't constant or repeated leakage or seepage. Those are discrete events that occurred from a drain line, not a supply line. I think repeated would be, and it's got to be cause, drip, drip, drip from like a supply line. And over time, over 14 days, after that, if that causes damage after the 14th day, that can be excluded if they prove it. And the burden of proof was on them, went to the jury. They did not prove that.
So on 465, 466, where they're talking about running a hose out from the tub outside, was that just for a test or demonstration, or was that how they fixed the problem with the tub or shower?
Is it the tub or the shower? The hose that I have, they ran out of the washing machine.
Well, it says from we took off the P-trap from the guest bathroom laboratory, made our own little extension piece, ran it out and so forth. So I don't know if that was for demonstration.
That's
purposes.
after the loss.
Okay.
That was after the loss. You know, the events that I just described are what occurred before the loss, and prompt notice went to the jury also. And so they haven't carried their burden of proof on that. They didn't argue, Phil, to Judge Jolly. They argued the interior damage. She properly let that go to the jury. Those are discrete events. They could argue all they want that that's over 14 days. The jury didn't buy it. Any other questions, though, on constant repeated leakage or seepage?
I mean, so if you're using the sink or dishwasher over this 4 to 5 month period, if you've used it more than 14 times, how does that play into the analysis here?
Well, first of all, they'd have to prove it. There's no evidence of that. And second, those are, if you use a washing machine and it causes a discharge on day one, and then don't use it, let's say, for 3 or 4 days. So you don't have constant. It's not repeated over 14 days. That's twice. But they got to prove that caused the damage. And then they've got to get it to 14 days. Repeated in this context means you got to drip, 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 and those drips ultimately cause damage. Say the back of in the back of a sink in the cabinet, you got a drip, and now you've got a piece of wood that has damage because of it's been exposure for over 14 days.
Mr. Nation, maybe I'm oversimplifying. You're emphasizing Hicks was a supply line. This is a drain line, right?
Yes, sir.
And because there's not constant pressure, it was the age, wear, tear, which is what your client's expert testified to. It was the age, wear, tear to the drain line that and the rust, corrosion, et cetera, that caused that drain line to fail. And therefore, as it may have been used periodically to allow water to escape when dishes were being washed or clothes were being washed or the kitchen sink otherwise in use, that use did not cause the drain line to fail, but ultimately the failure of that drain line caused the damage to the dwelling. Am I understanding you correctly?
You are.
And because of that, caused is an important word emphasized in Hicks, equally emphasized here. And therefore, the jury was entitled to rely on the testimony of your client's expert, in rendering the verdict they rendered, and thus we should affirm. Am I hearing you correctly?
Said it better than I did.
Am I oversimplifying the issue?
No, I think it's quite simple. Wear and tear, rust, corrosion, wear and tear in the pipes over time, and that's covered. You know, the policy says we don't cover loss caused by wear, tear, deterioration, corrosion. If it ended there, we wouldn't be here. But if those cause water damage from a plumbing system, which it did on March 1st, 2019, undisputed, opened claim, paid for interior water damage, if it causes that, we cover the loss caused by the water, including tear out.
And so ultimately, if we're sitting here reviewing an argument that error is assigned to the trial court because the trial court failed to enter a directed verdict, Judge Nardella, I believe, and Feltus even acknowledged that the standard that we applied, the same standard as the trial court, that the truth of all facts admitted into evidence and any inferences inure to the non-movement, i.e. your client.
Correct. And Mr. Jaremko said, based on everything he saw, not just a conclusion, he gave hours and hours of testimony about it. And that's not a constant repeated leak or seep. But it went to the jury. They could have ruled against me. I would have no recourse. That's what they picked. It is as simple as that. I'll quickly, if I can deal with the ACV, I know I only got a few seconds. They're just saying that ACV doesn't include tear out. There's no case whatsoever in this policy says the insured loss is for the water damage, including the tear out. And tear out is part of the insured loss. The loss settlement provision says we will pay the ACV of the insured loss.
All right, all right.
Thank
I
you.
assume you want us to affirm.
I do want you to affirm.
That's what I figured. All right. All right, thank you, counsel.
Thank you, Your Honor. I'm not hearing.
You're muted, Judge Lambert.
You've got 6:49 according to the marshal's clock. Go ahead,
Thank
ma'am.
you. Thank you, Your Honor. I'll pick up where Mr. Nation started trying to distinguish Feltes on two parts. He said that the policy language is different, and if we look at the policy language on page 16 of our policy, it's not different because it's exactly the same thing. It says, as specified above, is limited to only that part or portion of the covered building or other structure which is necessary to provide access to the part or portion of the system that caused the covered loss. So we're dealing with the same thing. So there is no distinction on Feltes there. And then he also tried to make a distinction about overtime versus 14 days or more. And again, the record testimony from not just the insured, but from Mr. Jaremko is that there were repeated events. And understand that, yes, sometimes it came up through the tub or the toilet or the kitchen sink or out of the washing machine when it was being used, because that liquid and other matter would try to drain and couldn't drain properly, so it would back up. These backups continued for 14 days or more. And the other thing that is incorrect here is that Mr. Nation is I was going to say suggesting, but he's actually stating that we failed to prove that it was 14 days or more, which we did not do because it's record testimony, and that it was our burden to prove the damages. We all know that it's plaintiff's burden to prove damages. So if plaintiff wanted to prove damage during the first 13 days, they need an estimate, and they didn't do that. Plaintiff didn't prove damages, and defendant did prove this exclusion. And Hicks, yes, talked about caused by, because anti-concurrent causation language was never argued in Hicks. It is so important to look at this lead-in language of the exclusion on page 19 that says we do not insure for loss caused directly or indirectly by the following. Such loss is excluded regardless of any other cause or event contributing concurrently or in any sequence. So we have a loss, and let's assume it's a covered loss, and it goes on for more than 14 days, which the testimony, the record shows. It went on for, these backups happened all over the house several times, went on for more than 14 days. And in fact, our record timeline will show us that Mrs. Justice testified as to all these events, and she didn't report until July. And even if they're talking about a May event, or I believe he said a March or a May event in 2019, she still didn't report until July. And the only thing she did, even though Mr. Nation keeps saying she took care of it, she replaced appliances that weren't covered under the policy. That's the only thing she took care of. She didn't stop the water backups. She didn't stop the exposure. And in fact, even on page 3 of Appellee's answer brief, about halfway down, it is Mr. Jaremko's testimony, quote, every time you flush the toilet, open a sink, new damage occurs. Water escapes out and it's creating new damage. Transcript 413, 2 through 11. Their expert proved that this was repeated seepage and leakage. She didn't do any mitigation of the water. She didn't do any repair to the plumbing system.
So
And
you're basically every time the toilet is being used, so over the whatever day one is, then we had the 14-day time frame under the policy. If the toilet's being used every day, it's not continuous, but it's repeated. And you're saying if the claim extends, if it's more than a 14-day time frame from when it starts till it's reported, then therefore this exclusion applies.
Exactly right.
Is that what, that's your argument?
That's my argument. Exactly right. And as evidenced in the record by plaintiff's own experts. And we know that she testified she lived there. She didn't move out. She didn't testify that she stopped using the toilet or the sink. And
So
they're
let me just pragmatically, I know that's always a dangerous term in the appellate world nowadays, but so basically when the first backup occurs and the insured or the homeowner says, well, oh, okay, I got to address this here. You know, my first response is not to make a claim. I got to try to fix the problem. And they keep trying to do that until eventually they're unsuccessful. If they haven't done something within that 14-day period, if it's toilet related or sink related or whatever, and then the expert comes in and testifies as he did, it sounds like the insured, almost as a matter of law and fact, is never going to win that claim. I mean, they have to do something within the first 14 days saying, all right, my toilet's not working. I'm not going to worry about fixing the toilet. I got to go make my claim and call the insurance company.
well, and understand that this is not a neglect.
Is that, am I being overly dramatic here? Or is that
No.
in essence what actually
No.
has to happen?
The insurance company excludes things that go on for 14 days or more because
So you as the homeowner have to have the wherewithal saying, okay, I don't know what my policy says. I'm having a problem in my home. I need to call my insurance company and say, look, before I do anything, I'm going to put you on notice on day 2. I have this backup.
well, let's not take it from November of 18 then.
Well, I'm
Take
not
it
using the
from-
dates here. I'm just
Right.
trying to understand the concept here.
Right, but let's use their date of loss, which was March of 2019. And actually APT was out there, and APT, instead of saying there's something wrong with your dishwasher, there's something wrong with your disposal, there's something wrong with this other appliance, because we know she kept trying to replace these appliances and kept, in her terms, having floods and backups and overflows. Okay, so APT goes out and APT says your cast iron plumbing system is shot. She still makes no repairs to the cast iron plumbing system between March of 2019, well, and today, but her report date is July, months later. After she finds out it's actually the cast iron plumbing system, there's still more than 14 days that passes.
Okay. All right.
It's,
Your time has expired, counsel. So, all right. Thank you very much. We'll take our advisement. Well argued. Enjoyed listening to the world of drain pipes. It's interesting.
Thank you all.
thank
All
you
right,
for your
take
time.
care. Thank you.
Bye.
We're adjourned.